There was testimony from Hope Hicks and Madeleine Westerhout, who were two people who worked for Trump in the White House. They were brought in as witnesses to testify about White House conduct. So they wrecked the trial by introducing bad evidence, and they could terminate the proceedings without vacating the jury verdict or dismissing the indictment. Oh, that's interesting. Judge Merchan is not going to be mad at Trump for what he did. Then his future sentencing is not going to be impacted by that. Obviously, that is insane, right? Alvin Bragg, the Trump prosecutor in New York, wants to sentence the president. Other cases have been dismissed. Even Jack Smith, who's completely illegitimate, submitted voluntarily to dismiss the January 6th case in Washington, D.C., to dismiss the appeal in Florida on the classified documents case. But Bragg is saying, no, we know that we were scheduled for a sentencing on this. Remember, Trump was already found guilty on 34 counts of falsifying business records in one of the biggest scam trials we've ever seen that involved perjurer Michael Cohen and Stormy Daniels, porn star, who got up there and introduced wild evidence that the judge never should have allowed in, that even he admitted. So they're going to continue to push forward to incarcerate Trump, theoretically, even though he's won the presidency. Everybody else is dropping their case, but Alvin Bragg, who got embarrassed with his corrupt prosecution of Daniel Penny, even New York jurors could see through that one. But the criminal jurors in the Trump prosecution voted unanimously for all 34 of those counts because the crime there was pick a crime, any crime. They could have chosen any object offense that they wanted. So there were legal problems, there were political problems. It was a mess. But they're not dropping this case. They want to continue and do something with sentencing. And so Alvin Bragg has submitted this to the judge. Before this document came in, President Trump submitted a motion to dismiss the entire case from the incoming deputy director and his associate deputy director, Todd Blanche and Emil Bove, submitted the response saying, we want this case dismissed immediately right now. This is Bragg responding to their demands. He says this court should reject Trump's motion to immediately dismiss this indictment and to vacate the jury's guilty verdict based on the outcome of the election. There are no grounds for that relief now. And prior to Trump's inauguration, because he doesn't have immunity right now. And even after the inauguration, Trump's temporary immunity as the sitting president does not justify discarding the jury. Okay, so the immunity is temporary, meaning soon as he goes into the White House, it force field shields up. Soon as he leaves the White House, shields down. Can't do it, Captain. As defendant does not dispute the 34 felonies of which he is convicted, he says, involve purely unofficial conduct and not any official presidential acts. And I think, that's kind of a debatable point. Now, at most, Trump should receive temporary accommodations during his presidency to prevent this criminal case from meaningfully interfering with his presidency. So it's a pause. He wants to pause the prosecution. But multiple accommodations well short of dismissing this and a vacatur, which would eliminate the case, would satisfy that objective. Now, the relief that Trump wants doesn't serve a public interest because the jury already found him guilty. They say Trump's also remaining arguments also don't support dismissal. Trump provides no basis whatsoever for this court to revisit his prior complaints. Instead, we've got overwhelming evidence of guilt, and so you cannot dismiss this case, not in the interest of justice at all. Now, they say, Your Honor, you cannot dismiss this case under New York law because you can only dismiss it in the interest of justice. What does interest of justice mean? They say, well, here's the standards. There's a lot. Seriousness of the offense, the extent of the harm, the evidence of the guilt, the history and characteristics, and so on. But here, he's going to give us some more breakdown on why this sentencing can proceed. Bragg says, 1, there is no Article 2 immunity to the president-elect. So right now, Trump is not immune. And so you cannot stay the sentencing in that manner. Now, they're going to respond and say, well, we have the Transition Act, right? The Presidential Transition Act that protects a president-elect as well. That's Trump's response. Trump also says that the Supremacy Clause also intervenes. We don't want state prosecutors who are corrupt partisan hacks like Bragg and Fannie to be able to deviate the presidency. Trump cites a range of authorities, as we saw, Presidential Transition Act, Justice Department guidance, and all that, which has been sufficient, right? Jack Smith read those same documents and dismissed his cases. But they say that goes too far. In addition to relying on this theory of pre-presidential immunity, they also say that when he becomes the president, it's going to have to be dismissed also. They say, no, he hasn't been inaugurated yet. He's going to be soon, but it hasn't happened yet. And so he's wrong that it requires dismissal when he becomes the president. He says, let me be clear. We do not dispute that when he is president, at the time, he has immunity. But dismissing the indictment and vacating the jury verdict is not warranted because we can do other things. He says, if judgment has not been entered before he becomes the president, so he's like, let's try to squeeze this in before Trump takes office. If it doesn't happen, the court could at that point stay further proceedings for the duration of Trump's presidency. presidency. Okay, so we'll just kick this down the road as soon as he leaves in 2029. Then we'll pick this back up. They say that it would be appropriate. We can balance the competing interests here. It's not going to run afoul of Article 2 immunity. It's not going to impair his rights to a speedy trial. It's not going to impede on his presidency. And so just wait. Now, that is, I think, in direct opposition to other guidance. Having the president, part of the problem is the president is constantly thinking about this case when he's been elected to do the job. They say the fact that Trump will become the sitting president is not dispositive. Can't handle this. You can't dismiss this case right now. Rather, the appropriate analysis involves balancing the competing public interests. And so because it's so important to us, here, the charges are purely personal and unofficial conduct. They're not even presidential acts. Now, the issue with this is that in the trial, they used a ton of official presidential acts. There was testimony from Hope Hicks and Madeline Westerhout, who were two people who worked for Trump in the White House. They were brought in as witnesses to testify about White House conduct. So they wrecked the trial by introducing bad evidence. Now, second, because immunity is concerned only with protecting the president's ability to do his job, if we pause this case, that will be achieved. There is importance in making sure he's criminally accountable after his term expires, they're saying. And as particularly relevant here, we are not going to extend immunity to block state criminal subpoenas, so why should we do that here? Now, Trump's request ignores the limitations of presidential immunity. Neither the Supreme Court nor the Office of the Legal Counsel has addressed the impact of presidential immunity. And if you grant a dismissal, it's going to give him immunity beyond his presidential term for unofficial criminal conduct. And I think in the charges, every single charge was alleged when he was the president. All of the checks were written after January 1st, 2017. So I'll be curious to see what Todd and Emil Bove say in response to this, because I don't think that is their official position. Dismissal and vacature would effectively extend the defendant's period to before his presidency. They're saying he's not immune now, but the charges that they brought against him when he was the president, he was actually signing the checks. They were dated in 2017 when he was in the Oval Office. They're saying that was excluded. But we never came to a determination whether certain conduct that was brought in as evidence, what bucket it fell into. In addition, outright dismissal would have consequences after the presidency because then the public couldn't come and prosecute him. And they continue. He says, also, Jack Smith's cases doesn't matter to us. Finally, they say you should do what Jack did. But that's different than here for several reasons. The disposition of Trump's federal prosecution doesn't matter to us. There are significant procedural and substantive differences. The parties were still engaged in pretrial motions here, and our case is different. And so we're better than Jack Smith, and we're going to continue our prosecution. And we can also do other things, Your Honor. Like if you're not, don't dismiss this. Just continue the sentencing. But if you're thinking about dismissing it, here are some other options. As noted, he should receive accommodations while he is the president, but we have other options short of dismissing this indictment. Here are a couple of those options. This proceeding could be stayed until the end of his presidential term. Just postpone it for 4 years. The OLC said maybe you can do something like this, and they raised concerns about the stigma if a president is prosecuted, but we can accommodate his status here. We can say there will be no new criminal obligations, okay? He already knows about these. These are all fully litigated. This case is mostly done. There will be no new criminal obligations, so he's just going to have the current ones. And separately, if he's not sentenced before his inauguration, like they want to get that in, there is no legal barrier to deferring that sentencing until after the end of his presidency. You can do that. There are well-settled standards. He can hardly complain about a delay in sentencing when he's already sought a delay. He's already asked for a delay. Sentencing in this case was originally scheduled for July 11th, but then we postponed it. Then on August 14th, Trump wanted to postpone it, right? Trump was asking for continuances until after the election. So it's well settled. So since he wants some delays, you can delay this for 4 years. The delay would be constitutional because it is intending to protect the functions of the presidency. And finally, even assuming that he had a claim of unreasonable delay to just let this case sit around, a violation of speedy trial rights or something, here the parties can only speculate about what could happen 4 years from now. The courts may resolve this on future motions, like you might decide to dismiss this later, and he could raise those issues in 4 years if he has a problem with that. So this court could adopt a remedy also that has been used in abatement by death, and they could terminate the proceedings without vacating the jury verdict or dismissing the indictment. Oh, that's interesting. So this is like a reversal of the Hunter Biden case. Remember, in the Hunter Biden case, Hunter Biden wanted his case dismissed, gone. The prosecutor wanted the case terminated. In this case, the prosecutor wants this case terminated, and again, Trump wants this dismissed. So it's basically the same parallel. Even if this court were to believe that the mere pendency of this criminal proceeding were somehow inconsistent, a dismissal and a vacature is not warranted. Under abatement, courts have considered an analogous question of what to do when someone dies. In New York, they allow us to do this. this: the judgment of conviction is vacated and the indictment is dismissed on the ground that the defendant's death makes any further appeal impossible. Now, that was the rule. Your case is gone. Your case is dismissed because you're dead. A large majority of states no longer, and that actually happens, right? You go to the judge, hey, Your Honor, here's the situation. Okay, bring me the death certificate and you're done. And to the prosecutor. Such a rule, and instead have adopted a less disruptive remedies to better respect the public interest. So the court could do an alternative to this in place of this. So the judge would have to kind of get crafty here. Specifically under the Alabama rule, when a defendant dies after he's found guilty, but before the conviction becomes the final through the appellate process, the court places in the record of the case, and that's interesting because now Bragg is saying, is this before the conviction? Is that what he's implying? Like, is this case analogous to Trump's case because there's not a conviction here? To the effect that the conviction removed the presumption of innocence, but was neither affirmed nor reversed on appeal because he died. In this way, the Alabama rule abates the criminal proceedings, doesn't vacate the underlying conviction or dismiss the indictment. So the case stays on the record. The verdict is on the record. Now, as applied here, this court could similarly terminate the criminal proceeding by just placing a notation in the record that the jury verdict removed the presumption of innocence. Okay, that's what they want. That the defendant was never sentenced and that his conviction was neither affirmed nor reversed on appeal because of presidential immunity. Like, they want kind of pseudo conviction, like it's an asterisk conviction. Well, he's not presumed innocent anymore because there is a verdict. He was never sentenced, and it's almost like a pardon, right? Like Hunter, his case is not dismissed because it's terminated due to a pardon. This is not dismissed, it's terminated due to presidential immunity. Same argument. It makes sense to borrow from the manner in which the courts address abatement because of defendants' arguments. They parallel this in New York. Now, I don't know if they can do that in New York. We were talking in the other cases with Hunter and these motions, those were federal cases. This is a state case. So, for example, they say the court argues that the court cannot subject him to further criminal proceedings during his term in office, and he's transitioning now, and that is a punishment. So Trump also argues that in the instant case, he cannot be brought to its conclusion because his appeals will not be resolved, and you don't get to just terminate your presumption of innocence. Okay, Hunter Biden accepted the pardon. I guess you could say he was happy with that outcome. Although Trump is accepting the immunity, so Trump is happy with that outcome because his appeals will not be resolved, and Hunter, in his one case, it was the same situation. So this parallels the finality rationale for abatement. Adopting something like Alabama would better balance the competing interests here. To be sure, New York law does not expressly provide for this remedy. Okay, so there. So, but judiciary law, this is Alvin Bragg admitting that, well, you can't actually technically even do this because Trump was convicted. And if Trump wanted, like Hunter Biden had the right to go appeal his stuff if he did not want to accept the pardon. And I guess you could say, maybe make that same argument here, but Trump has been elected. And so he actually needs the immunity in order to do his job. Now, limits on future proceedings could also address his concerns. So you could say if he's going to be worried about this while he's in office, the court could also address those concerns by saying in the future, if we are going to sentence you, you could say that his conduct during his presidency will not play a part in his sentencing, right? So Judge Merchan is not going to be mad at Trump for what he did. Then his future sentencing is not going to be impacted by that. Obviously, that is insane, right? Now Judge Merchan could have commentary on Trump's entire presidency and sentence him to jail. Here, a decision by this court to disregard his conduct would diminish or eliminate any prospects that a future sentencing hearing would impact his official decisions. Yeah, right. Merchan is one of the most biased judges I think we've seen on this channel because of his daughter was literally making money off of his coverage of the case. They say also, how about we just tell Trump we won't put you in jail? Limit the possibility that he will face jail. He's got no prior criminal convictions. This is a Class E felony. And so you're not required to put him in jail. And so if we agree that you will not put him in jail, then you can go ahead and sentence him, right? Don't discard the jury verdict altogether. Now, this is interesting, right? He says New York law does not allow this remedy because the pardon power is a very broad power. And Trump has due process rights in not having a conviction stand. So it's like you're trying to make him choose between his appellate rights and his presidency rights. So the judge cannot do this, but it's like the perfect out for him, to be honest. I wonder if he's going to try to finagle that in. We'll see what Todd Blanche says in response to this, along with Emil Bove. They should have a reply to this coming in hot. We'll get it when it comes in, and we'll see what Judge Merchan does. We'll be here to continue to cover it, my friends. Thanks for subscribing and joining as we do.